Thank you, Lenka. It's a real honor to be participating in this event with so many people whom I respect and admire. And the issue that we work on is really as old as organized society. We've had a new name recently in the media, whistleblowing, but this has always existed. As long as there have been institutions, there have been leaders of those institutions and members who have abused their power. And as long as they've abused their power, somebody's stuck their neck out and challenged it and gotten smashed for doing so. It's an ancient, timeless phenomenon. But we have had a legal revolution in whistleblower laws since 1978. There have been now 29 nations that have dedicated whistleblower laws, 6 intergovernmental organizations from the United Nations to the African Development Bank, which have developed whistleblower policies. And the pace is accelerating rapidly, as Mark pointed out. There's 30 more that are on the books and pending. The problem is, while we've had a legal revolution in laws, we haven't had a revolution in free speech rights yet. Passing laws, as I have learned from painful experience, is the first step in a marathon journey. And the primary lesson that I've learned from helping pass 32 whistleblower laws is that weak whistleblower laws actually are counterproductive. We'd be better off without them. They're worse than nothing. They increase the chilling effect, cynicism, and associated secrecy when the rights in practice do not reflect reality. And too many of these reforms are traps. They create more victims than they help. They're free speech Trojan horses that are professionally fatal for those who rely on them. As a result, organizations like the Council of Europe, the Organization for Economic Cooperation and Development, various NGOs have developed best practices to distinguish effective laws or metal shields from ineffective laws or cardboard shields. And why do we use that term? Well, you know, when you go into battle with a metal shield, it's dangerous. But you got a fighting chance to survive. You go into battle with a cardboard shield, no matter how beautifully it's painted and how gaudy it looks, you're going to die. And the biggest challenge for our movement, in my opinion, is the main principle of healers. First, do no harm. And from that context, I'd like to go over the best practices and some examples for them that we've seen in the 29 whistleblower laws and 6 policies that are in operation. The first is a context for freedom of expression with no loopholes. Oh, and sorry about the forgetting on the PowerPoints. Arbitrary loopholes based on formality, context, time, audience, they not only dilute the law's potential to make a difference, they create a lot of uncertainty and confusion for whistleblowers when they have rights and when they don't, which can create an associated chilling effect. One of the loopholes that I've found the most counterproductive is the whistleblower's motives. That for some reason they have to have selfless motives or pass the martyr test in order to have rights against retaliation. Some of the whistleblowers are about enhancing the flow of information so that we can make informed, responsible decisions, or so that we can enforce justice in the rule of law. And it may matter for the credibility of their information, whether a whistleblower's motives are nefarious or evil or competitive or revengeful, or whether they're idealistic and noble. But it doesn't matter for the point of these laws, which is to get the evidence on the record that we need. Laws that are very good in this, countries that are good in this is Korea, U.S. corporate whistleblower laws, the U.S. Whistleblower Protection Enhancement Act, which just closed about 50 loopholes that had been introduced into that law. The European model, which permits public freedom of expression based on criteria. You have to be internal first, but you're not a prisoner of internal procedures. And you can have public freedom of expression if you demonstrate a fear of retaliation, a likelihood of destruction of evidence, an imminent threat to the public, or a failure of the institution to act when you had tried to work through internal channels. Let's go to the second one then, subject matter for free speech rights with no loopholes. Now, whistleblower laws must protect all disclosures evidencing abuses of power that betray the public trust. Otherwise, the law's potential, again, will be diluted. There'll be an associated chilling effect due to uncertainty of when you have rights and when you don't. The U.S. Whistleblower Protection Act was the beachhead for this principle by not only protecting disclosures of illegality, but disclosures of gross waste, mismanagement, abuse of authority, or substantial and specific dangers to public health or safety. More modern laws have expanded on that beachhead. For example, many laws now protect against challenges to the environment, against challenges to different animals and species who live in those nations. Or the Slovakian law, which I don't think could be any broader, any disclosure about large-scale damage. The scope of the free speech laws has to be adequate. The third principle is one that we're not doing so well on. That's the right to refuse to violate the law, to go beyond making noise and actually walk your talk, refuse to participate in illegal activity. The U.S. is again a beachhead on this. It's in the Whistleblower Protection Act in our country and all the recent corporate laws. International governmental organizations also have adopted this principle, which is very encouraging. And some nations are beginning to. It's in Liberia's whistleblower executive order, for example. But this is still the exception rather than the rule. And it's an exception that needs to be erased. The fourth criteria that I'd like to talk about is protection against spillover retaliation. A responsible whistleblowing disclosure, it requires a lot of advanced preparation. You've got to do your homework, have your evidence there. You have to work with others to obtain evidence, to corroborate your conclusions. Oftentimes people come to me and they're very honest. They've got the snapshot syndrome. They saw something which looked horrible, but they didn't have enough context to draw the conclusions which they started to. I think of a picture of a snapshot of a smoking gun. And the smoke's coming out of it, and we think, aha, smoking gun, best evidence. Well, if the bigger picture is a dead body in an alley with blood coming, all around, well, then it probably was critical evidence of a crime. If the bigger picture is a target practice range to learn safe marksmanship, it didn't prove any misconduct. A whistleblower has to do that homework. And an effective law must protect those who are engaged in advanced research, who assist or corroborate information from other whistleblowers, who are associated with whistleblowers, or even when they've been mistakenly accused of whistleblowing. This principle is in the U.S. laws, it's in the World Bank's law, the Organization of American States, the African Development Bank, the Irish Protected Disclosure Act, the Japanese Whistleblower Act, Serbia's new Whistleblower Act. It's becoming something that institutions are recognizing, nations are recognizing. You don't just protect the immediate act of free speech. You have to protect the whole context, the whole project of getting the truth out. The fifth criteria that I'd like to go into is no loopholes protection for all citizens with relevant evidence. Too many of our whistleblower laws, and it's the case in my country, are just there to protect against employment harassment. But the protection has to extend to all who have relevant evidence for an organization's mission. At a minimum, based on current or former employment, and they should be protecting any citizen who has evidence which could make a difference. Serbia's new law does that, for example, and it's becoming very common. About a dozen of the world's whistleblower laws now are not limited to the employment context. The sixth criteria is reliable confidentiality protection. This is important for two reasons. One is to prevent harassment, but the second is to help sustain the free flow of information. Once a whistleblower is identified, they become isolated and the flow of information to them dries up, except through underground channels, potentially. And it can be very, very important that they are allowed to continue on the job and continue developing the proof of their charges in order to be effective in making a difference. Many potential whistleblowers will just remain silent observers because of fear of backlash or retaliation if their identities are revealed unnecessarily. Reliable anonymity protection means more, however, than just blanking out somebody's name, whiting it out, or removing it. It means also removing all the identifying information that could be traced back to the whistleblower, particularly when only a few people were witnesses to misconduct. Just disclosing certain facts can be the same as the whistleblower's signature. You don't need to say their name. A second thing that's important here is to clearly establish the limits for confidentiality protection. It's a minority of cases, and I always warn people who come to us at GAP that if you really want to make a difference on this, sooner or later you're going to have to come out of the closet and bear witness with testimony on the record. You may not have to, but very likely that's going to be part of it if you want something to be accomplished by sticking your neck out. And that's not always voluntary. It may be that the government criminal investigator has to disclose your identity in order to keep the case from dying. Well, that needs to be warned in advance. People know what's the limits of their rights. And when it is necessary to disclose someone's identity, confidentiality protections have to include a requirement for advance warning, so that the person isn't in the horrible situation of going to work thinking that they're a confidential whistleblower and being confronted by a hysterically angry boss who's going to pull them in and start giving them the third degree and not only firing them, but finding out all the evidence that the government has for their investigation. This is something which most of the laws respect, although they're not getting all the full dimensions of confidentiality protection. Some of the new ones, such as Serbia's law, are very sensitive to that. Some nations even have criminal penalties for disclosing a whistleblower's identity. Australia has 6 months. Uganda has 5 years. Jamaica has $2 million fine and 2 years imprisonment. Malaysia has 10 years imprisonment. The problem with these, however, is that nobody's gone to jail or been fined for disclosing a whistleblower's identity. So they're kind of paper tiger aspects of those laws. Let's go to the next criteria. Protection against unconventional harassment. Now, the forms of retaliation are limited only by the imagination. I'm constantly impressed with the ingenuity of bullies, how many different ways they can come up with to creatively destroy a whistleblower's career or life. So credible laws can't be limited to a list of illegal harassment tactics. They have to be flexible and ban any retaliation that creates a chilling effect by placing whistleblowers at a disadvantage. For example, a very common increasing tactic is to open criminal investigations or prosecute whistleblowers rather than fire them, take retaliatory employment actions. This is far worse chilling effect than an employment action. It's much easier to do. You don't have all the muss and fuss of coming up with formal charges and having a hearing and maybe dealing with appeals and legal rights. All you need is one good criminal investigator who's a bully and can scare the whistleblower, terrorize the whistleblower with the potential consequences. You can't lose with criminal investigations and witch hunts. All that happens is if you don't succeed, you close the case. And then next week or the next month, you can start a new case on a new pretextual charge. It can never end. I had one whistleblower I worked with who was under nonstop, no, it wasn't nonstop, who was under criminal investigation for 30 years. He was challenging bribery in the Chicago meat yards. He was challenging corruption. He would be under investigation for a year or two. He was completely honest. There was never any evidence. They'd close the case. And then a month later, they'd open up a new one on him. It never ended. And the chilling effect is far worse. Scaring people into silence is much easier if you're threatening them with jail than with the necessity of finding a new job. I'm very pleased that unlike my country, the United States, where we don't have any rights against criminal harassment, and we've seen some of the prosecutions that have occurred, 13 nations now have whistleblower laws that protect against all criminal liability as well as all civil liability. When a big company, for example, files a lawsuit, which may be frivolous, it may not have much merit to it, but they've got so much money that they can spend the whistleblower into defeat and ruin. These whistleblower laws are very, very significant breakthrough. What's the 8th criteria? Shielding whistleblowers from gag orders. I don't know how many times I've seen, well, we've got a free speech law on one hand, and then we've got another law which says it's illegal to engage in the same activities. Well, which one prevails? An effective whistleblower law has to override, supersede any current or future rules that contradict or create exceptions to its rights. They can only be modified by amending the whistleblower law. It has to supersede and have supremacy over any conflicting statutes, or else you have a horrible chilling effect. Anti-gag laws are now routine in all the United States whistleblower laws. Great Britain's PETA has that, Australia, Jamaica, Serbia, Malaysia, Uganda, India, Zambia, New Zealand, South Africa. I'm very pleased that the primacy of this principle is achieving its rightful place. The 9th criteria, support services for your paper rights. In all too many instances, if you're not a lawyer in the United States, you don't even know you have whistleblower rights. They do surveys, and less than 10% in some of these surveys are even aware that they have free speech rights. And then there's the managers who are supposed to respect them. They don't know about them either. These are rights on paper, but they're more theoretical and academic than having an impact on reality. And the foundation for all this support is training. Training for the employees, training for the managers on their liabilities and what they're risking by crossing that line, as well as informal agencies to give them guidance and counseling. The Office of Special Counsel in the United States performs that function. And under our Whistleblower Protection Enhancement Act, every Office of Inspector General now has to have a whistleblower ombudsman whose job is to help teach people and advise them when they're walking on thick ice and when they're walking on thin ice and they're liable to fall in. I'm very impressed with Serbia's new law because it requires every employer to hand out a statement of rights to its employees, a statement of responsibilities to the employers themselves. And in Serbia, they've trained every judge who's eligible to hear a whistleblower case. Unlike my country, where a lot of the judges really just don't know the law, you're not eligible to hear a whistleblower case in Serbia unless you've first been certified as having completed that training. Well, now let's go to what's probably the cornerstone principle, the right to a genuine day in court. The law must include due process rights to present your evidence and confront your accusers in the forums reserved for society's highest stakes issues. They have to be independent from conflict of interest. Too many laws in my nations, too many policies, and some of the laws are enforced by the people who should be the defendants in a real trial. But instead of being the defendants, they're the judge and juries of their own misconduct. And the whistleblower law gives the employee the right to ask them to change their minds. Well, this turns these rights into a bad joke. These turns rights into requests. And you have to have independent access to these courts. And it needs to be to all of the courts. Like in the U.S. Whistleblower Protection Act, we have access to administrative remedies for government workers, but not to the courts with jury trials like the corporate employees have in our country. In Serbia, they have access to the courts, but the whistleblower protection law there no longer provides access to administrative agencies who have lost their authority to enforce those rights. A lot of people can't afford to go to court. You have to have this applicable, whether it's the bargain enforcement process or the luxury enforcement process. You should be able to enforce your rights wherever you want to. The 11th is the right to independent binding alternative disputes resolution. This is something which can be particularly valuable in nations where the judicial system is still in its growing pains, where it's not reliable, where there might be a lot of corruption in those forums. To have an independent arbitrator with subject matter expert who is agreed upon by both sides. This is something which is used routinely to enforce international agreements, trade agreements, and it can work. In the United States, for our Whistleblower Protection Act, if you're a member of a union, any whistleblower retaliation is a violation of your collective bargaining agreement. And that gives you the right to independent arbitration. And the success rates are many times higher in those arbitrations than they are in the administrative hearings that are otherwise available. Well, the next standard is the one that I've made the most significant in my work, and that's realistic standards to prove violations of your rights. The lawyers call them the burdens of proof. These are the rules of the game for how much evidence is needed to be protected under the law, how much evidence is necessary for each side to win in a lawsuit. You know, and if you're, say you're in some type of athletic competition and the bar is this high, you may have a good chance of getting over that bar. If the bar is way up there, you don't have a snowball's chance in a sauna of prevailing in that competition. They have to be fair rules. And I'm very happy that most nations, while they don't have detailed burdens of proof, increasingly nations are requiring a reverse burden of proof, that the employer has to prove that they were not retaliating once protected activity is established, rather than the employee having to prove that they were victimized. The standard that has worked in the United States and that's been adopted by most of the intergovernmental organizations, the United Nations, the World Bank, African Development Bank, is one that says the whistleblower must show that his or her exercise of free speech was relevant to or a contributing factor, played some role, affected in any way the decision which is being challenged. And if that happens, the employer has to prove by clear and convincing evidence, not just a majority of the evidence, 51%, clear and convincing evidence, 70 to 80%, that it would have acted, not that it could have, if they do a witch hunt and find some dirt in the whistleblower, no, that it would have taken the same decision if the employee had remained silent. The next criteria is a realistic time frame to act on your rights. You know, it can take a real campaign just to find a lawyer and who will take your case and gather the evidence that's necessary to win in a lawsuit. And with the ignorance that many people have, and particularly in our country, they won't even know about their rights. They don't know they have them until it's too late to use them. 6 months, in my opinion, is the minimum limitation for acting on your rights. Many nations have longer statutes of limitations. The U.S. statutes of limitations range from 30 days in some of our primitive early statutes to 3 years in some of the more recent statutes. This is important. The next criteria I'd like to go into is no loopholes compensation. Otherwise, if you're not made whole, you may end up losing by winning. And that's just going to increase cynicism all the way around. It has to at least be a make whole damage remedy. And the more effective ones are ones that provide punitive damages to punish the wrongdoer. And that can mean that you don't just get back to even. You actually have a little cushion, which can help you have a fresh start. The best practices on this include our False Claims Act in the United States, which gives you double your back pay. Our transportation whistleblower laws, which allow punitive damages up to $250,000. And whistleblower laws around the world are adopting this principle. Korea, Ghana, Serbia, Slovakia, Liberia, Zambia, all of the PETA laws are now structured to allow make whole relief if you prevail. The next one is interim relief. In my opinion, in my experience, this may be the most significant factor in making a difference. If a lawsuit goes on for years and years, it may not matter anymore that the whistleblower won. They're ruined. They've lost their home. They've gone bankrupt. Their family may have dissolved on them. It's like no matter how good the law is, if you don't get timely relief, it's like the patient who dies on the operating table before the world-famous heart surgeon can get there for the transplant. Doesn't matter anymore. And if you get quick relief, the employer will likely settle the case on terms that allows both sides to move on in a civilized fashion they can accept. If it's going to take you years to win that case, the employer will starve you out. They'll just delay and delay and delay because nothing's going to happen until all the appeals are completed, and they know the whistleblower can't afford that delay. In the U.S., we have interim relief as a significant portion of our laws. Bosnia can have interim relief within 3 days. Serbia, the judges have to act within 7 days on interim relief. Slovakia has the one that I think is the very best, though. Once you have been granted status as a whistleblower, the employer has to get government approval before they take any action against you. And I hope that that's a precedent that sticks. For nations that, some of the nations like the United States, attorney fees is a very routine part of the act. If you can't afford a lawyer, you're not going to be able to defend yourself. Some of the IGOs provide legal assistance. Some of the countries provide legal assistance. You're automatically entitled to legal aid if you're doing a whistleblower lawsuit. The next criteria to go into is they call transfer preference. It's very unrealistic to go back to work for a boss you've just defeated in a lawsuit. It doesn't work very well. In the U.S., half the people who won their whistleblower cases were fired within 2 months of going back to work. You can never turn your back again, even if you do succeed. So there has to be an opportunity for a fresh start. The IGOs do this, the United Nations, the African Development Bank, OAS. The U.S. has that in our Whistleblower Act. Korea does, Serbia, Liberia, Slovenia, Zambia. This concept is catching on. The next criteria to go into is accountability for retaliation. Otherwise, the bureaucratic bully has nothing to lose. The worst that'll happen is that they won't get away with it. And even if they don't get away with it, they may get promoted because they proved they were willing to do the dirty work. And so the organization knows, okay, here's somebody we want to give more power to. They'll do whatever we want them to with it. They've got nothing to lose. Most of the whistleblower laws are now having some type of accountability, deterrent value. A lot of them have criminal penalties, like Australia, Korea, Malaysia, Uganda. The United States, you can be put in prison for 10 years for retaliating against a whistleblower. There's a problem with criminal accountability, in my opinion. You know how many times we've used this in the United States since 1980 when it was first adopted? 0. They don't get prosecuted. The people who retaliate don't get prosecuted. In my opinion, the best way to do this is to give the whistleblower control of the process for accountability by letting them include that in their lawsuit. Seeking punitive damages, such as some of the ones that I discussed in our laws. In Malaysia, they have included that in their law. The whistleblower has to be able to fight back, not just depend on the government to fight back for him or her. The 19th criteria is credible corrective action. The lack of credible corrective action is, after everything we talked about with harassment and retaliation, the #1 chilling effect in every study that's been done has been cynicism, that it won't make a difference if I stick my neck out and challenge this abuse of power. And, you know, doesn't that make sense? Most people do have, you know, they've got courage, they're gutsy. Most people are willing to fight and die for their country. And, but who accepts somebody who's kind of neurotic or, you know, has a victim complex, is going to keep beating their head against the wall if the only thing that happens is they crack their own skull? They're doing this for a reason. And if people are going to continue to act under whistleblower laws, they have to know that it's going to have an impact. The U.S. False Claims Act, for example, has increased our annual recoveries against fraud in government contracts from an average of about $10 million a year to over $1 billion a year by deputizing whistleblowers. The final criteria that I'd like to discuss is review. You know, it started out this talk by saying, you know, bad whistleblower law can be counterproductive. An awful lot of these laws in practice, as we study their track records, they're really not worth the paper they're written on. And is that such a ground for cynicism? Well, not really. You know, it's growing pains. How many people can walk really effectively, you know, when they're 3 or 2? You have to have lessons learned. In the United States, we're in our 4th generation of whistleblower law. The same rights since 1978. But we had to learn our lesson for how they were circumvented, how are the loopholes created, how are the purposes of these laws frustrated. And it's an ongoing, continuous process. If retaliation is a timeless phenomenon, the process of fighting retaliation effectively has to be just as timeless. And to my disappointment, this is one of the areas where we don't have so many nations with best practices. But it is starting to take root. Australia has it, the Irish Public Disclosure Act, the Jamaican Public Disclosure Act, the Japanese Whistleblower Protection Act. Those have structural review built into them to see what needs to be revised in order to meet the original law's purpose. That's my overview of some of the lessons that we've learned about a timeless phenomenon. And thanks for hearing me out.